You got about 30 seconds to explain what you're doing on this property before I make this a very bad night for you. The parking lot at Riverside Mall was mostly empty by then. Zone D, the far end, away from the entrance lights. One row of yellow sodium lamps, one of them flickering. A dark sedan correctly parked, space 14, and Damon Ellery standing beside the driver's door, hands loose at his sides, saying nothing yet. Officer Garrett Pruitt had already chosen the outcome. He just hadn't told Damon that part. If this kind of story matters to you, stay with it. What comes next is the part they were counting on you to never see. Pruitt was a large man. Not tall, exactly, broad. The kind of broad that fills a door frame and knows it. He walked with his right hand already resting on his belt, not the holster, but close enough that the message was clear. He stopped 6 feet away, looked Damon up and down, once, the way people do when they've already decided, and said it again, slower this time. 30 seconds. I'm not asking twice. Damon looked at him. Not down, not away. At him. His voice, when it came, was even. Good evening, officer. Is there a problem? Pruitt's jaw moved. Yeah, there's a problem. You've been standing here 20+ minutes on private property after hours. That's a problem. He had been there 12 minutes. The camera on column P4, the one Pruitt hadn't looked for, hadn't thought to check, had been recording since 8:21 p.m. Pruitt didn't know about the camera. He also didn't know that the man standing in front of him had just mentally cataloged his badge number, his patrol car's unit designation, and the exact timestamp showing on his own dashboard clock through the windshield, and the precise wording of the notice posted on the column 4 feet to Damon's left. A notice that read, in full, private property, Harlan County Retail District Authority. No loitering. Persons remaining on premises after business hours without active transaction may be subject to removal under Florida Statute Section 810.09. Business hours ended at 9 p.m. It was 8:41. Damon had not been asked to leave. He had not been given notice. He had not refused anything. Pruitt took one step forward. ID now. May I ask what this stop is based on? Don't give me that. The words came out practiced. The sound of a man who had used that exact phrase so many times, it had worn smooth. You're standing alone in a parking lot at night. That's what it's based on. The ID. There was a pause. Not hesitation. Calculation. Damon's right hand moved. Deliberately, slowly, announced before it moved. My hands are going to my right jacket pocket. Slowly. Pruitt watched the hand. He didn't answer. He was watching for something he could name later and not finding it. The license came out. Florida issue, address on Crestline Avenue, photograph matching the face in front of him. Pruitt took it, looked at it for 4 seconds, handed it back without a word. Then, turn around, hands on the roof. On what basis? Suspicious behavior, loitering. A pause. And because I said so. He would write those words in his incident report 2 hours later. Because I said so. Not a legal standard, not a statute. 3 words that would appear, verbatim, in 7 separate documents over the next 3 months. Damon turned, placed his hands on the roof of his own vehicle. The metal was warm from the day's heat, not yet cooled. He felt the cuffs. Pruitt applied them without warning, without telling him they were coming, clicking them tight. And then, into the still air of Zone D, Damon spoke, not loudly, not urgently, but with a precision that was something other than panic. I'd like to note for the record, it is 8:43 p.m. I am being placed in handcuffs at the Riverside Mall, Zone D, near column P4. Officer's badge number is 441. Pruitt went still for exactly 1 beat. Not afraid, confused. The people he cuffed did not do that. They cursed, they pleaded, they went quiet. They did not recite location coordinates and badge numbers like they were filling out a form they'd practiced on. Get in the car. Damon got in the car, but he didn't argue, didn't pull. He sat back in the rear seat, looked at the headrest in front of him, and closed his eyes for 3 seconds. Not in fear, not in exhaustion. He was counting. Pruitt keyed his radio at 8:44 p.m. The transmission was captured automatically by the department's dispatch server, archived, time-stamped, accessible. 14 to dispatch. Got one in custody. Loitering, suspicious. Bringing him in. A pause. Dispatch. Copy that, 14. Any charges? Another pause. Shorter than the first. Then, not yet. Let me see what he's got. 3 weeks before that night, Damon Ellery had unpacked the last of 3 boxes in a third-floor apartment on Crestline Avenue, East Bridge neighborhood, Harlan County. The building had 11 units, a broken intercom on Unit 7, and a superintendent named Pete, who answered maintenance requests in 3 to 4 business days, except for plumbing, which he handled immediately because he'd had a bad experience with a ceiling in 2019 and never wanted to repeat it. The apartment itself was spare. A table, 2 chairs, a bed, a shelf of books organized not by author or genre but by thickness. From left to right, thinnest to thickest, with one exception. A slim blue notebook, worn at the spine, that sat flat on the surface of the shelf rather than standing with the others. Damon had been in Harlan County for 8 months by the time of the arrest. He'd told his neighbor, a woman named Delphine Oates, who knocked to borrow salt within 48 hours of his moving in and had knocked every few weeks since, that he worked in financial compliance consulting. Contract work. He traveled for it sometimes. Delphine had accepted this the way people accept information they don't fully believe, but also don't care enough to challenge. With a nod and a vague, "That must keep you busy." It did. His mornings had a sequence. Not a ritual exactly. Rituals are for comfort. This was functional. Coffee first, black, no sugar, while the water for the pot was still running. Then the table. Phone placed face down on the left, wallet on the right, the blue notebook in the center. He would open it, scan the last 3 entries, close it. Only then did he eat. The blue notebook was the kind sold in office supply stores for $2.49, the kind that no one looks at twice. He'd had 14 of them over the years. This one was on page 61. Of the morning of September 19th, the day Pruitt would arrest him, Damon had done 4 things before noon. First, coffee, notebook, review. Second, a trip to Riverside Mart, the grocery store inside the mall complex. He scanned each item himself, bagged them, and left. Third, the county property management office on Birch Street, where Damon went to renew his short-term lease for a second quarter. The paperwork was complete. Form RL7, downloaded from the county website. Printed, filled by hand, signed. The woman at the front desk, whose ID badge identified her as Brenda, looked at the form and then looked at him. "We need a secondary ID utility bill or prior lease." "That's not listed in the renewal requirements. I have the RL7 from your site, dated last month." Brenda glanced sideways at the woman seated next to her. A look of about 1 second. Then she looked back. "Policy may have changed. I'll need to check with my supervisor." Damon waited 22 minutes. Brenda processed the form without further comment when the supervisor did not appear. He wrote the file number in the blue notebook before he left the building. Fourth, back to the apartment, where he opened the notebook, added 1 line, and then sat for 11 minutes doing nothing visible, which, for Damon, was not the same as doing nothing. At 8:17 p.m., he drove to the Riverside Mall parking lot and pulled into space 14 in Zone D. He sat in the car for 2 minutes with the engine off. He opened the notebook, wrote 3 lines, closed it, and put it in the glove compartment. Then he got out of the car and stood beside it, hands loose, and waited. He was there to meet someone. At 8:41 p.m., Garrett Pruitt's patrol car rolled into Zone D instead. The person Damon was waiting for never arrived. They had been watching from half a mile away when the patrol car's lights swept across the lot, and they did the only thing the situation allowed. They left. The Harlan County Police Department's 5th District substation sat on the corner of Meridian and Caldwell, a squat building with a parking lot that held 12 cars and usually held 9. Damon arrived in the back of Pruitt's unit at 9:02 p.m. He was processed through booking, photographed, prints taken, personal effects logged, 1 wallet, 1 set of keys, 1 phone, 1 pack of rubber bands. No notebook. It was in the glove compartment of his car, which was now unattended in Zone D of a private parking facility. He was placed in a small room with a table and 2 chairs. He sat in the one facing the door. He folded his hands on the table surface and waited. Pruitt came in at 9:19 p.m. without another officer present, without a recording device running, or so he believed. And the department's room-level audio logs had been activated 2 months prior as part of a general system update. The notice had gone out by email. Pruitt received it. He had not read past the subject line. "You want to tell me what you were doing out there?" Damon looked at him. "I'd like to speak with an attorney before answering any questions." That was the end of the substantive conversation. Pruitt spent another 6 minutes in the room, asking variants of the same question, receiving the same response, once leaning forward with his forearms on the table, in the way that is meant to compress the space between 2 people. Damon did not lean back. He did not lean forward. He maintained the same posture he'd walked in with. At 9:41 p.m., Pruitt left. He told the duty officer that the subject was uncooperative. The room audio recorded all of it. At 11:15 p.m., after an internal consultation that Damon was not present for, he was released. No charges filed. The incident report, written by Pruitt, finalized at 11:48 p.m., time-stamped and submitted to the department's record system, read in relevant part. Subject detained for suspicious loitering, Zone D Riverside Mall facility, 8:41 p.m. Subject released after verification. No charges warranted at this time. It did not mention the 20-minute claim Pruitt had made at the scene, which the camera would later show was false by 8 minutes. It did not mention that Pruitt had entered the interview room without a second officer and without informing Damon that the request for an attorney had been logged, and it did not note what probable cause had existed for the initial stop. It mentioned suspicious loitering. That was the entire legal foundation. Damon read the report later. A copy obtained under Florida Statute Section 119.07, the Public Records Act, submitted in writing the morning after his release. He underlined suspicious loitering with a pencil. Then he turned to a fresh page of a new blue notebook and began. The Office of Public Affairs at the Harlan County Police Department occupied a corner suite on the 2nd floor of headquarters. Sheila Brandt had held the director's position for 6 years. She was good at her job in the specific way that made her job difficult to criticize. She was never inaccurate. She selected. She framed. She chose which verbs carried which actions. The morning after Damon's detention, She issued a statement that went to 3 local news outlets before 9 a.m. The Harlan County PD responded to reports of suspicious activity in the Riverside Mall retail complex last evening. A male individual was briefly detained for questioning and released without incident. The department thanks the community for their continued partnership in maintaining safe commercial areas. Every clause was defensible. Responded to reports. There had been a report, technically. Pruitt had logged the stop as officer initiated based on observed suspicious activity, which was a report of a kind. Briefly detained, 11 hours, 11 days, or 11 minutes are all brief relative to some longer period. Without incident. No charges, no physical injury documented. When the Harlan Gazette ran a 3-paragraph summary at 9:14 a.m. under the headline, "Man detained at Riverside Mall, identified as area resident." Damon was described as an area resident with no prior record. He had lived in Harlan County for 8 months. He was not from out of state. The distinction mattered to him less than the process error, which was this. Brandt had characterized the stop as a response to community reports. There were no community reports. Someone had chosen that word. Responded, knowing what it implied without stating it. He documented this in the blue notebook at 10:47 a.m. At 10:52 a.m., he walked into the public lobby of the Harlan County Police Department and asked for the formal records request form for obtaining a copy of the incident report from the previous evening. Sheila Brandt saw him from the second-floor window. She watched him fill out the form at the lobby counter. She watched him hand it back to the desk officer. She watched him leave. She picked up her phone and made a call she would later describe, under oath, as routine coordination. The formal records request came back 9 days later, within the statutory window, technically. With the incident report attached, 3 pages, the version Damon had expected. He read it once at the table, marked 2 passages, and put it in a folder he'd labeled with a date and a case reference number he'd assigned himself. He filed his formal complaint with the Internal Affairs Division of the Harlan County PD the same afternoon. The complaint cited 4 specific procedural failures. First, the absence of articulable reasonable suspicion to justify the initial Terry stop, as required by Florida case law interpreting the Fourth Amendment. Second, the factual inaccuracy in the incident report regarding the duration of Damon's presence in Zone D. Third, the failure to advise him of his right to counsel before initiating questioning in the detention room. Fourth, the absence of a second officer during custodial interview, in violation of Department SOP Section 7.4. He had pulled that SOP from the department's public documentation portal, where it had been posted as part of a transparency initiative 2 years prior. The complaint was 8 pages long. It was typed, not handwritten. It had numbered footnotes. The duty officer at the IA desk received it, logged it, and assigned it to the investigator on rotation. And that investigator was Marcus Fevery. Court Dillard had been the lead attorney for the Harlan County Police Officers Association for 11 years. He was the kind of lawyer who never raised his voice in a room and never needed to. He requested a meeting with Damon through a neutral intermediary, a mediator at the county's Community Dispute Office, within 5 days of the complaint being filed. The meeting was framed as informal dialogue toward resolution. Damon agreed to the meeting. He brought his folder. They sat in a conference room at the dispute office, a beige room, fluorescent lighting, a water pitcher nobody touched. Dillard came with a legal pad and 2 pens. His questions were organized. Mr. Ellery, at the time Officer Pruitt approached you, were you asked at any point to leave the premises? No. Your vehicle was legally parked? Yes. Zone D, space 14. 2-hour free parking, operational until 9 p.m. I was there from 8:29 to 8:41 by camera record. A pause. Dillard wrote something. You seem very certain of the time. I noted it. Another pause. Dillard changed direction. Did you, at any point during the interaction, make any statement or gesture that Officer Pruitt could reasonably have interpreted as threatening or non-compliant? I asked the basis for the stop. I announced my hand movement before reaching into my pocket. I stated the time and location after being cuffed. And I requested an attorney before answering questions in the detention room. Dillard looked at his legal pad. He made a mark that was not a word. Where did you come across the specific procedural citations in your complaint document? I read the relevant statutes and the department's SOP, which is public. You read the SOP. It's 42 pages. The section I cited is on page 19. Dillard's pen stopped moving. He looked at Damon across the water pitcher and the untouched glasses. He had interviewed hundreds of complainants over 11 years. Most of them were angry. Some were frightened. A few were opportunistic. The person sitting across from him was none of those things. He was something Dillard found genuinely difficult to categorize, and difficult things made Dillard careful. He closed his legal pad. I appreciate your time, Mr. Ellery. They shook hands. Dillard left first. In the elevator, he made a note on his phone. Not about the complaint. Not about probable cause or SOP violations. He wrote one word: careful. Marcus Fevery had been with the Harlan County PD for 17 years, 12 in patrol, 5 in internal affairs. He knew Garrett Pruitt the way men know each other when they've eaten in the same cafeteria for a decade. Not friends exactly, but the comfortable familiar. People who knew what the other liked in their coffee without having to ask. He accessed the IA file for the Ellery complaint on the first morning it was assigned to him. He reviewed Pruitt's incident report. He noted the discrepancy in the timeline, 20 minutes claimed versus 12 on camera, and made a note to verify the camera footage. His note entered into the IA digital log at 10:34 a.m. Zone D camera coverage reviewed. Coverage quality insufficient for incident reconstruction. No request submitted to property management. He had not contacted Riverside Mall management. He had not requested the footage. He had looked at the department's internal mapping of mall security camera coverage, a document that was 3 years old and did not account for a system upgrade the mall had implemented 18 months prior, and used it to conclude that no usable footage existed. This was not technically a lie. It was a conclusion unsupported by actual investigation, entered into a log as if it were verified fact. He moved on. The same afternoon, Damon Ellery walked into the Riverside Mall management office on the ground floor of the retail complex and asked to speak with the property manager. Terrence Good was a careful man in the way that property managers become careful. He'd seen slip and falls, he'd seen theft. He'd seen a food court fight end in a lawsuit. He had opinions about liability. He met Damon in his office, behind a desk that held 4 clipboards and a schedule printed in a color-coded grid. I need to request preservation of camera footage from Zone D, specifically the period from 8:20 to 9 p.m. on September 19th, Damon said. I understand your system may record over previous footage on a rolling basis. I need it held. Good looked at him. You involved in an incident? I was detained in your parking facility by a Harlan County officer that evening. I have a complaint filed with the department's internal affairs. I'm requesting the footage as potential evidence. Good nodded slowly. Give me the date and time again. Damon gave it. Good wrote it down. He pulled up his system log, found the relevant file, and flagged it manually for retention. "It'll stay," Good said. "Anything else?" "I'd appreciate written confirmation of the preservation request and the timestamp of this conversation." Good looked at him again, the same look, slightly different quality. "Yeah, okay." He printed a one-page confirmation letter on Riverside Mall management letterhead, signed it, dated it 3:47 p.m., September 20th, and handed it across the desk. Damon put it in his folder. The story that appeared in the Harlan Gazette 2 days after the complaint was filed did not have Nadia Cross's byline. It had no byline at all. It appeared in the community notes section, 3 paragraphs, under the heading, "Local Man's Background Under Scrutiny, Following Incident at Commercial District," where it said that an anonymous source within the county had expressed concerns about the unusual pattern of movements of the detained individual, described as a frequent visitor to various commercial properties in Harlan County, whose purpose remained unclear. It noted that no charges had been filed, but suggested the matter warranted further attention. Nadia Cross read it the morning it published. She was the Gazette's senior investigative reporter, and she had not written it, had not been consulted about it, and did not know which of her colleagues had. The editor, when she asked, said it had come in through the community tip line and been approved by the news desk. She drove to Crestline Avenue that afternoon and knocked on the door of apartment 3C. Damon opened it. He recognized her from her photo in the paper. "Oh, someone fed me a story about you," she said without preamble. "I'm not printing anything, but I want you to know it's circulating." "What kind of story?" "The kind where they don't have evidence, but they want people asking questions before the evidence does." He said nothing for a moment. Then, "Miss Cross, do you have a FOIA contact at the county records office?" She looked at him. He was not reacting to the anonymous story the way people reacted to things being said about them. He was moving. Not forward exactly. Sideways, around. "I can get you one," she said. "I'd appreciate it." She left him a card. He left her a question. "The Gazette has county-level FOIA records going back how far?" 12 years online, longer in archive." He wrote this down. She went back to her car and sat for a moment in the driver's seat, not starting the engine. She had been covering Harlan County for 4 years. She had filed 43 FOIA requests. She had never had a subject of a story respond to a hit piece by asking about records access infrastructure. She started the engine. She had something to look into. Marcus Fevery received a call that evening from a number he saved in his phone under the name CG. The call lasted 4 minutes. There is no record of its content. What is known is that at 8:02 p.m., 17 minutes after the call ended, Fevery accessed the IA file for the Ellery complaint and added a secondary notation. "Complainant's background, pending additional review." No review was ever attached to that notation. No review was ever conducted. Pruitt came back on the 22nd. He did not come alone. He brought Dale Rusk, younger, quieter, still in his 2nd year on the job, and operating at all times under the assumption that what the more experienced officers did was how things were done. They drove to Crestline Avenue in Pruitt's personal vehicle, not a patrol car, and parked across the street at 7:08 p.m. Damon was coming out of the building when they pulled up. He had a dry cleaning bag over one shoulder and a paper bag with 2 grocery items in his left hand. He saw the car. He saw who was in it. He adjusted nothing about his pace. Pruitt got out first. "Evening, Mr. Ellery." Easy, conversational. The tone of a man doing a wellness check. "Just checking in. How's the complaint process going?" Damon set the dry cleaning bag on his car roof and shifted the grocery bag to his other hand. "Fine. Thank you for asking." Rusk came around the front of the car. He stayed back, closer to the hood than to the sidewalk. But he was there, and the geometry of 3 people on a sidewalk at dusk means something, and everyone present understood what it meant. "Lot of paperwork, filing complaints," Pruitt said. "For everyone." A pause. "You planning on staying in Harlan long?" Rusk asked. Damon looked at him, then back at Pruitt. "I'm not sure what my plans have to do with an official visit." Pruitt took 1 step forward. Just one, not threatening by any legal definition. But spatial, deliberate, weighted. He was 6'2" and 230 pounds, and he had spent 18 years learning how the physics of proximity work. Damon did not move. He stood on the sidewalk with a grocery bag in his hand and held Pruitt's eyes the way a person holds a door open. Without effort, without drama, and without conceding the space. Pruitt studied him for 3 seconds. "Suit yourself," he said finally. They got back in the car. Damon watched them go. Then he set the grocery bag on the car roof next to the dry cleaning bag, took out his phone, and dialed a number he didn't need to look up. The call connected on the 2nd ring. "Contact was made," he said. "No incident. I'm documenting." 3 seconds of silence. Understood. The voice on the other end was a woman's, measured, unhurried. "Continue protocol." The call ended at 7:14 p.m. 51 seconds total. Damon looked at his phone for a moment, then put it in his pocket, picked up his bags, and went inside. Nadia Cross submitted her FOIA request to the Harlan County Records Office on the 25th. A bundle of 12 items covering a 3-year window. Internal communications between the HCPD Public Affairs Office and the IA Division. Officer complaint data by demographic category, and correspondence referencing Zone D of the Riverside Mall facility. She did not tell Damon she had done this. She didn't tell anyone. She had been doing this work long enough to know that the moment a FOIA request became known inside the department, the documents it would have found had a way of becoming unavailable. The response came 18 days later. 34 pages. Several of them blacked out in whole or in part, others entirely routine. Meeting agendas, parking lot maintenance schedules, on a 2-page discussion thread about a vendor contract for bodycam battery packs. Page 17 stopped her. It was an email chain. 2 messages. The bottom one was dated 9 days before the night Pruitt arrested Damon in Zone D. The sender field read, mfevery at harlancountypd.gov. The recipient, S. Sprant at harlancountypd.gov. Subject line, RE, Zone D/North Lot/Schedule Review. The body of the email was blacked out, all 3 paragraphs. The referenced attachment, labeled NL-D Survey Week 39, was noted as absent from the system. The top message was Brant's reply, also blacked out, except for one visible line at the bottom. Confirmed. Will coordinate accordingly. SB. Nadia read the chain 4 times. Then she printed it. Then she put the printout in a folder that she kept in a locked desk drawer at home, and not at the office. An IA detective had emailed the head of public affairs about a specific location, Zone D, North Lot, 9 days before a man was arrested in that specific location. The attachment was gone. The body was blacked out. The reply said, confirmed. She needed more. But what she had was already enough to make her careful about where she kept it. Lori Desmond had been a systems technician at the Harlan County PD for 4 years, which meant she had been present through 3 server migrations, 2 failed vendor contracts, and 1 catastrophic database incident involving incorrectly formatted time zones that she would not describe in detail to anyone who didn't already know. She was methodical. She ran her weekly system checks on Tuesdays, because Thursday checks got skipped during holidays, and she'd learned that lesson the hard way. On the Tuesday 3 weeks after Damon's arrest, she was reviewing upload logs from the body-worn camera fleet as part of a routine audit. The new system, installed 2 months prior, had an auto-upload function. When a patrol vehicle returned to the lot and the officer's device synced with the car dock, footage uploaded automatically to the server and was archived in a queue pending case tagging by the officer. Untagged files stayed in the queue. They were not deleted. They were not visible in the active case management system. They sat in an overflow partition, date indexed. She found the file in the September 19th overflow partition at 10:22 a.m. Device ID BWC-441. Assigned Officer G. Pruitt, Unit 14. New upload timestamp 22:47:03. That was 10:47 p.m., approximately 90 minutes after Pruitt had returned from the Zone D stop with Damon in custody. Duration 23 minutes, 14 seconds. Case tag none. She double-checked the assignment log. BWC-441 was Pruitt's camera. Pruitt had filed his incident report at 11:48 p.m. The upload had occurred at 10:47 p.m. There was a recording of 23 minutes from Zone D that had never been attached to a case file, had never been reviewed by anyone, and had not been deleted. Pruitt would later state in writing that his bodycam had experienced a sync failure on the evening in question. The upload log showed no sync failure. It showed a successful upload at 22:47:03. Desmond made a copy of the file to a secure drive. She logged her discovery in the system maintenance record, which was automatic and time-stamped. Then she forwarded the log entry to her supervisor with a flag. The flag read, "Untagged BWC footage from September 19th. May require IA review." Her supervisor read it. Her supervisor forwarded it, not to IA, to the records manager, who forwarded it to the deputy chief's administrative assistant. By the time it reached anyone who understood what it meant, it had been 6 days. But the file existed. Logged, time-stamped, copied. The system had done what it was designed to do, even when the people inside it were not. The audio from BWC-441 covered 23 minutes and 14 seconds. The portion that would matter most ran from timestamp 2041:08 to 2044:31. 3 minutes and 23 seconds, and it began with Pruitt's voice. "You've been standing here for 20 minutes. Then Damon's. "May I ask the basis for this stop?" "Don't give me that." A pause. Footsteps on asphalt. One set, moving closer. Damon's voice, measured and deliberate. "My hands are going to my right jacket pocket. Slowly." A sound. Fabric, zipper, the brief friction of leather against polyester. Then silence for 8 seconds. At 20:43:05, clearly audible. "I'd like to note for the record, it is 8:43 p.m. I'm being placed in handcuffs at the Riverside Mall, Zone D, near column P4. Officer's badge number is 441. Pruitt's response, "Get in the car." 47 seconds of near silence, ambient traffic, one car door, the mechanical sound of the patrol car door closing. Then Pruitt's radio transmission. At 20:44:31. 14 to dispatch. Got one in custody. Loitering. Suspicious. Bringing him in. Dispatch. Copy that, 14. Any charges? Then, not yet. Let me see what he's got. Not yet. Let me see what he's got. Not. I arrested him because he committed an offense. Not, I have probable cause for a specific violation. Not, the law requires me to determine this. Let me see what he's got. The stop came first. The justification was going to be assembled afterward from whatever turned up at the station. That was the sequence. The audio made it concrete. By the time the file found its way to someone at the IA level who understood its significance, the complaint filed by Damon Ellery had been sitting on Marcus Fevery's desk for 3 weeks, are progressively deprioritized, marked as pending additional documentation, a status that in IA practice meant it would remain pending until the complainant stopped pushing or the department found a way to close it with a finding of no policy violation. Fevery had, in those 3 weeks, interviewed Pruitt once, informally in the break room, for 22 minutes, no recording, and had submitted a preliminary internal assessment noting that the officer's conduct may have involved a procedural irregularity in the sequencing of Miranda advisement, but that absent documented injury or criminal complaint, the matter did not rise to the threshold of sustained misconduct. He had not requested the Riverside management footage. He had not checked whether bodycam footage existed. He had not interviewed Damon, the complainant, at all, and the blue notebook on Damon's shelf now had 47 entries. He had cross-referenced the IA division's published procedures with what had actually occurred in his case at each step. He had noted, in the margin of one page, a question. Who reviewed Pruitt's prior complaints? He pulled the answer from a public database the department maintained under Florida's Sunshine Law. Over the preceding 5 years, 7 complaints had been filed against Officer Garrett Pruitt. 6 involving black male subjects, 1 involving a black female subject. None had been sustained. 5 of the 7 had been assigned to the same IA investigator. He looked at the name, Marcus Fevery. He wrote it down. He did not act on it immediately. He let it sit in the notebook next to a date and a number. 7 complaints, 0 sustained, same investigator, 5 years. Some things were more useful when they were patient. On the 31st day after the arrest, Damon's phone rang at 4:17 in the afternoon. He was at the table. He looked at the number. It was a 813 area code, Tampa. He answered. Mr. Ellery. The voice was a woman's, even-toned, confident, the kind of calm that is trained rather than natural. This is Patricia Wade. I understand the situation has become complicated. I wanted to check in. He looked at the window. Crestline Avenue, the late afternoon light going sideways through the Venetian blinds. It's manageable, he said. The complaint is filed. Documentation is intact. The timeline is still viable? 6 weeks, if nothing else moves. A pause. Then, are you taking appropriate precautions regarding the secondary contact event? He understood what she was asking. She was asking about Pruitt's visit to Crestline Avenue. Documented and logged, he said. No escalation. Good. Another pause, shorter. We're adjusting the back end. You'll hear from me again in 10 days. The call ended at 4:18 p.m., 61 seconds. Damon looked at the notebook on the table. He opened it to a new page. He wrote, Wade, 10 days, adjustment. He underlined, adjustment. Deputy Commissioner Sloan Avery had been in law enforcement for 31 years. He had started as a patrol officer in a county smaller than Harlan and had worked his way through a series of positions that each came with an incrementally larger office and an incrementally larger sense of what it cost to rock a boat. He was not corrupt. He was what comes after corruption has been in a system long enough to normalize. A man who had learned that most problems resolved themselves if you gave them enough time and didn't ask them to resolve faster. He reviewed the Ellery complaint at the request of Commissioner Tolman, who had received a call from the district supervisor about the FOIA requests circulating through the county records office. That call had made Tolman uncomfortable. Tolman making phone calls to Avery was how uncomfortable feelings got redistributed. Avery read the complaint. He read Fevery's preliminary assessment. He made a note. He called a meeting of 3 people, himself, Fevery, and the department's legal officer, a woman named Caitlin Morse, who had the specific legal temperament of someone who would rather be clear than right. Durhai said, "The complaint lacks specificity in terms of documented injury or demonstrable harm. The detained individual was released without charges. There's no physical evidence of misconduct, and the IA review is ongoing. I don't see grounds for escalation at this stage." Morse looked at her notepad. The complainant has obtained camera footage from the property manager, and there's an open question about whether body camera footage exists. Has that footage been formally introduced into the IA record? Not yet. Then, at this stage, we proceed on the existing record. He looked at Fevery. Continue your review. Make sure it's thorough. Fevery nodded. At this stage. The phrase that means, we are watching and hoping the situation simplifies itself. Outside the building, on a bench in the small plaza adjacent to the county municipal complex, a woman in a gray blazer was reading a printed document. She had a coffee in one hand that had gone cold. She was reading slowly, the way you read something you're not sure you believe. She was not a lawyer. She was not a police officer. She was Nadia Cross, and she was reading the preliminary IA assessment, which she had obtained through the same FOIA channel Damon had pointed her toward. And she was composing in her head the 8 questions she was going to need answered before she could publish anything. The email on page 17 was not enough. The assessment was not enough. But together, they were 2 points of the same line, and she had covered enough local corruption to know that you never find the 3rd point by waiting for it to appear. You go find it. She folded the assessment into her bag, picked up the cold coffee, and stood up. She had 4 phone calls to make before dinner, and one of them was to a records clerk at the county who owed her a favor from a story she'd sat on 2 years ago. She began walking. The bodycam file reached the HCPD's Internal Affairs Division on day 38, forwarded from the records manager's office with a routing note that described it as potentially case-adjacent material requiring review. It landed in the IAQ on a Thursday afternoon and sat in the electronic inbox of the division supervisor, not Fevery, but his superior, a lieutenant named Gerald Hess, until Monday morning, when Hess opened it, listened to approximately 90 seconds, and picked up his phone. He called the department's legal officer first. "We have a problem," he said. The problem was this. The 23 minutes of footage, combined with the dispatch log and the incident report, created an evidentiary sequence that did not support the characterization of the stop as properly grounded in reasonable suspicion. The radio transmission, not yet, let me see what he's got, appeared at timestamp 20:44:31, 1 minute and 23 seconds after the cuffing was audible. The incident report's stated basis, suspicious loitering, was not articulated by Pruitt during any of the audible portion of the stop. The timeline discrepancy, 20 minutes claimed, 12 minutes documented by the property camera Good had preserved, was now verifiable. Hess forwarded the file to the county attorney's office. The county attorney forwarded it to the district supervisor. The district supervisor made a call. The call set in motion a process that would not be visible for another 2 weeks, but that had already, in its first hour, moved past the threshold of anything Marcus Fevery's quiet log entries could contain. Pruitt found out about the footage on a Tuesday, not officially, but through the same informal network that had been insulating him. Someone told someone who told him. He was in the parking lot of a Waffle House at 6:45 a.m. when he got the text, and he sat in his car for 11 minutes reading it 3 times. He had believed the camera hadn't uploaded. He had believed this because he did not fully understand how the new sync system worked, and because he had not asked, and because no one had told him, and because he had wanted to believe it. The footage is in the system. He put the phone in his cup holder. He thought about who he needed to call. He thought about what he would say. He thought about the radio transmission. Not yet. Let me see what he's got. And understood, perhaps for the first time, what those 6 words sounded like to someone who hadn't been standing in that parking lot at 8:44 p.m. with 18 years of knowing how these things go. They sounded like exactly what they were. He called Dillard at 7 a.m. The call went to voicemail. He called the union rep. That one was answered. The conversation that followed was not recorded, but its shape was predictable. Here is what I know exists. Here is what I'm worried about. Here is what I need you to do. The union rep told him to stop talking to anyone, put nothing in writing, and wait. Pruitt sat in the Waffle House parking lot for another 6 minutes, and then he went in and ordered breakfast because he didn't know what else to do with the next hour. And the body keeps doing ordinary things even when the situation has stopped being ordinary. Damon received the formal IA hearing notice on day 41. It was a standard document, 2 pages, letterhead, time-stamped, informing him that his complaint had been advanced to a formal IA disciplinary hearing scheduled for the following week. He was invited to appear and present supporting materials. The hearing would be conducted before a 3-person review panel and would follow the department's established IA procedural framework. He read it once. He put it on the table next to the blue notebook. He opened the notebook and looked at what he had. 47 entries. The footage confirmation letter from Terrence Good. The incident report with his pencil underlines. The Pruitt complaint history. 7 entries, 0 sustained. Same investigator, 5 years. The IA preliminary assessment from Fevery. The FOIA bundle, including page 17. One by one, he put copies of each document in a folder labeled with the hearing date. Then he put the phone number Patricia Wade had called from into a text message. Typed 4 words, hearing scheduled. Week 6, and sent it. The reply came in 40 seconds. Confirmed. I'll be there. He read the message, set the phone down, looked at the folder. He had not planned this. Pruitt had created this. But the sequence that Pruitt had started, the stop without probable cause, the false timeline, the interview room without a second officer, on the incident report that preceded any evidence of an offense, had been documented, layered, verified, and preserved at every step. Not because Damon was extraordinary, because he had been careful and patient, and because he had known, from the moment Pruitt's patrol car swung into Zone D, that the only currency that mattered in a room full of people who controlled the records was a record they couldn't touch. He had built one. Outside on Crestline Avenue, the evening was coming down over the streetlights, and somewhere across the city, in a 3rd-floor office of the county administration building whose nameplate had been changed 3 times in 1 year, a screen glowed with an open email. Someone was reading it. Someone was deciding, and in 9 days, in a beige conference room where nothing was supposed to happen, a woman in a gray blazer would open a briefcase, remove a document sealed in a clear cover, and say 5 words that would make the room go so quiet you could hear the ventilation system. 5 words that Garrett Pruitt, sitting across the table, would not understand for a full 3 seconds. And then, when he did, his face would do something that none of the training, none of the union lawyers, none of the 18 years of knowing how these things go had ever prepared him for. If this story has ever made you feel like the system is rigged and accountability is a myth, keep watching. Because what happens in that room is exactly what they said could never happen here. The hearing room was on the second floor of the Harlan County Public Safety Building. A beige conference room, as promised, with a rectangular table, 8 chairs, fluorescent lighting that hummed at a frequency slightly below conscious awareness, and a single window overlooking the east parking lot. It was the kind of room designed to make everything that happened in it feel procedural and therefore manageable. Patricia Wade walked in at 9:52 a.m., 8 minutes before the hearing was scheduled to begin. She came with one other person, a man in his mid-40s carrying a document case, who sat down without introducing himself and opened the case and began organizing its contents with the efficiency of someone who had done this exact thing in rooms like this many times before. Wade herself sat at the side of the table, not at the head, not across from the panel, adjacent, like someone who was not there to argue, only to clarify. The 3-person review panel was already seated. Lieutenant Gerald Hess, who had found the bodycam file and understood exactly what it represented. Captain Denise Okafor, who ran the 5th District and had spent the prior week reading everything she could find about the Ellery complaint with the focused attention of someone who sees a lawsuit forming at the waterline. And Deputy Commissioner Sloan Avery, who had told Hess 3 weeks ago that he saw no grounds for escalation. Court Dillard sat across from the panel with a yellow legal pad, 2 pens, same as always, and the particular stillness of a man who had been told something was coming and didn't know what shape it would take. Aunt Garrett Pruitt was at the far end of the table. He was in his uniform, not patrol, dress, and he had his hands folded in front of him in a way that was meant to project calm and instead projected effort. Damon Ellery came in at 9:58. He carried a single folder. He sat down, placed the folder on the table, and looked at the panel. He did not look at Pruitt. Hess opened the hearing. He read the standard procedural language. This is a formal IA disciplinary hearing. The matter before the panel is the complaint filed on September 20th by Damon Ellery. All parties have received notice of today's proceedings. The panel will hear from both sides and may ask clarifying questions. Findings will be issued within 14 business days. Dillard went first. He was organized and he was professional, and he said, in measured language, that Officer Pruitt had exercised reasonable judgment under conditions of uncertainty, that the complainant had been released without charges and had sustained no documented physical harm, that the procedural questions raised in the complaint were technical in nature and did not rise to the level of sustained misconduct, and that the appropriate outcome was a finding of no policy violation, with a notation recommending that Officer Pruitt complete additional training on the sequencing of Miranda advisements. It was a sound argument. It would have been a sufficient argument in most versions of this hearing. Then Hess looked at Patricia Wade. Ms. Wade, you've indicated you have material relevant to the panel's deliberation. The panel will hear it. Wade did not open a folder. She did not look at notes. She looked at the panel and said it the way you say something you have said before. Clearly, without drama, the way facts sound when they have stopped needing to be argued. My name is Patricia Wade. I'm the supervising agent of the FBI's Tampa Field Office, Civil Rights and Public Corruption Unit. I'm appearing before this panel because the subject of your proceeding is a federal operative whose cover was compromised during the incident under review. The room did not make noise. The ventilation system kept humming. Dillard put down his pen. The individual you know as Damon Ellery, Wade continued, has been deployed in Harlan County for 14 months as part of a federal investigation designated Operation Clearwater. I am not at liberty to detail the full scope of that operation at this stage. What I am able to tell this panel is that the operative's cover identity, his reason for being at Zone D of Riverside Mall on the evening of September 19th, and his association with specific individuals in this county were all components of an active undercover deployment. The stop by Officer Pruitt, which exposed the operative's identity to at least 3 individuals within this department before today's hearing, forced an acceleration of the operational timeline by 6 weeks and required the deployment of additional field resources to compensate for the compromise. She placed one document on the table. A single page, FBI letterhead, a case designation at the top that began with a series of numbers and ended with the word Clearwater. This document is a summary authorization letter for my presence at today's proceeding. It confirms the operative's federal status as of the date of the incident. The panel may retain a copy. The man who had come in with her slid a copy to each panel member without being asked. Avery looked at his copy. He looked at it the way a person looks at something they had been prepared to dismiss and have just discovered they cannot. Dillard recovered first. He was a good lawyer, which meant his instinct under pressure was to protect the process. "With respect," he said, "the panel's jurisdiction here is limited to the conduct of Officer Pruitt under department policy. The federal status of the complainant, if accurate, is a matter for separate proceedings. It does not speak to whether Pruitt had reasonable suspicion at the time of the stop. It speaks to the consequences of the stop," Wade said. "Well, that's a different question." "It is, and both questions matter to this panel." She looked at Hess. "The panel may weigh the federal implications as it sees fit. I'm not here to control the outcome. I'm here to ensure the panel has complete information." Hess nodded. He looked at Damon. "Mr. Ellery, you've submitted materials in support of your complaint. The panel will hear them." Damon opened his folder. He did not stand. He did not begin with context or history. He began with the first document and worked forward. The footage from Riverside Mall Zone D, columns P2 through P6, covering 8:20 to 9 p.m. on September 19th. The file was flagged for preservation by the property manager, Terrence Good, at 3:47 p.m. on September 20th, the day after the incident. That confirmation letter is in your copies. Hub of the footage shows my vehicle arriving at 8:29 p.m. and parking in space 14. It shows me exiting the vehicle at 8:31. It shows Officer Pruitt's patrol car entering Zone D at 8:41. The footage is continuous, with one exception: an 11-minute gap from 8:33 to 8:43, which the mall's system log attributes to a recording error. That gap coincides precisely with the period during which someone, in some sequence, made decisions about what happened in that parking lot. He said it without emphasis. The weight was in the fact itself. The incident report states that I had been present for 20-plus minutes. The footage prior to the gap shows 12 minutes of presence. The bodycam audio, at timestamp 2041-08, on records Officer Pruitt stating, "You've been standing here for 20 minutes." The footage contradicts this. The bodycam is the department's own equipment. The footage is the property manager's own system. He put the next document on the table. The bodycam audio from BWC 441, uploaded automatically to the department server at 10:47 p.m. on September 19th. The upload predates Officer Pruitt's incident report by 1 hour and 1 minute. The report states the camera experienced a sync failure. The upload log shows no failure. It shows a successful upload. He paused for exactly 1 second. The audio at timestamp 2044-31 captures Officer Pruitt's radio transmission. Not yet. Let me see what he's got. This transmission occurred after I was in custody, and it indicates that the determination of probable cause was intended to follow the detention, not precede it. Dillard began to speak. That transmission can be interpreted. The panel will let Mr. Ellery finish, Hess said. Damon looked at the third document. The IA file for this complaint was assigned to Detective Marcus Fevery. Detective Fevery's investigation log, which I obtained under Florida Statute 119.07, notes at entry 10:34 a.m. on September 20th that Zone D camera coverage was reviewed and found insufficient for incident reconstruction. No contact with Riverside Mall management is documented in Detective Fevery's log. The camera footage was preserved by me, independently, at the property manager's office at 3:47 p.m. on the same day. 9 hours after Detective Fevery's log entry. If Detective Fevery had contacted Riverside Mall management, he would have found what I found. A footage file that existed was intact and showed something inconsistent with the incident report. He put the fourth document on the table. A FOIA response, document 17 of 34, obtained by a member of the press and provided to me. An internal email from Detective Marcus Fevery to Sheila Brandt, Director of Public Affairs, dated 9 days before the incident. Subject line, RE, Zone D/North Lot/Schedule Review. Body text redacted. Attachment removed from the county system. The reply from Director Brandt, also redacted, contains one visible line. Confirmed. Will coordinate accordingly. He looked at the panel. I am not characterizing this document. I am placing it in the record and asking the panel to request its unredacted version under the investigative authority of this proceeding. He closed the folder. The document speaks for itself, he said. All of them do. Pruitt was asked to respond. He had been prepared for the complaint. He had been prepared for the body cam. Dillard had worked through the radio transmission with him 3 times, building a framework around the word yet that tried to recast it as a statement of procedural sequence rather than an admission that cause came after the cuff. He had not been prepared for Wade. He had not been prepared for the phrase federal operative. He looked at his folded hands. I made a judgment call, he said. The area had prior incident reports. He wasn't explaining himself. And in my experience, what prior incident reports? Okafor asked. Pruitt looked up. Ma'am. Zone D, you said the area had prior incident reports. Can you identify them? A pause. I'd need to check the system. They're not in your report. It was... He stopped. It was general knowledge in the district. We knew that lot. General knowledge, Okafor said. She wrote something. Wade said nothing. She did not need to. Hess asked the question that mattered. Officer Pruitt, at the moment you told Mr. Ellery he was being detained, before you placed him in handcuffs, what specific articulable fact gave you reasonable suspicion that a crime was being committed or was about to be committed? Pruitt looked at him. He looked at Dillard. Dillard gave him nothing, not because he was abandoning him, but because there was nothing to give. And he was standing there, Pruitt said, alone, at night, in a commercial parking lot during posted operating hours, Hess said, adjacent to his legally registered vehicle, which was parked correctly in a marked space. He wasn't explaining himself. He's not required to. The room held the silence after that for a moment. The hearing ran for 2 hours and 17 minutes. The panel did not deliberate in the room. They recessed, and the recessed portion took 4 days. During those 4 days, Pruitt was placed on administrative leave pending the panel's findings. This was standard procedure and was not, his union rep told him, a finding of guilt. It was a procedural status. Pruitt went home. He did not call anyone from the department. He did not write anything down. He did what his union rep had told him to do, which was nothing, and found that doing nothing when your career is in review is its own particular form of punishment. Dillard requested access to the unredacted version of the Fevery-Brandt email. The county attorney's office cited the investigative exemption under Florida Statute Section 119.0712. C. The same exemption Fevery's own IA log had been using to shield documents, and denied the request. The denial was, technically, lawful. It was also the kind of denial that, when noted in a hearing record, tells a careful reader that there is something there worth protecting. Nadia Cross published her first story on day 47. It ran on the front page of the Harlan Gazette's digital edition under the headline, "Internal Documents Raise Questions About HCPD's Handling of September Arrest." It detailed the timeline discrepancy on the bodycam upload log, the FOIA email, and the IA investigation process. It did not name Damon as a federal operative. Wade had been clear about what could and could not be published at that stage, and Nadia was a reporter who understood the difference between what she knew and what she could say. The story named Fevery. It named Brandt. It quoted the radio transmission in full. "Not yet. Let me see what he's got." By noon, the story had been picked up by 2 regional outlets. By evening, it was national. Commissioner Tolman issued a statement by 4 p.m. "The Harlan County PD takes all allegations of procedural misconduct seriously and is committed to a thorough and transparent review of the matters raised in recent reporting. The department is fully cooperating with the ongoing internal affairs process." Sheila Brandt did not issue a statement. She did not come to work the next morning. Her assistant told callers she was working remotely. Marcus Fevery came in at 8 a.m. the next day as usual. He sat at his desk. He opened his computer. He had read the Gazette story. He had read the radio transmission quoted in it. He had 17 years in this building, and an IA caseload of 43 open files and a pension that would vest in 3 more years. He sat at his desk for 22 minutes without opening a new document. Then he called a number he had not called in 8 days, and the person on the other end picked up, and Fevery said the following words: "They have the email." The silence on the other end lasted 5 seconds. Well, which version? The redacted one. But they asked for the unredacted. County attorney denied it, but the request is in the hearing record. Another silence. Then, "Sit tight." The call ended. Fevery put his phone face down on his desk. He looked at his computer screen. The open IA queue with its 43 files. The coffee that had gone cold beside the keyboard. The photo of his daughter on the far corner of the desk. She was 9 in the photo and was now 14 and would be 17 when his pension vested, if everything went normally. If everything went normally. He did not open a new document. He did not add to any log. He did not call anyone else. He sat there. The panel's findings came on day 51. 14 business days, as specified, almost to the hour. The document was 4 pages. Hess signed it. Okafor signed it. Avery signed it, though his signature was at the bottom of a page that contained language he had spent 3 days arguing against and 2 days accepting as the only defensible position. The findings were as follows. First, Officer Garrett Pruitt had failed to articulate a specific, articulable basis for reasonable suspicion prior to the initiation of the detention on September 19th, in potential violation of the Fourth Amendment and Department Policy 3.2.1. Second, The timeline stated in the incident report was inconsistent with physical evidence preserved by both the mall's camera system and the department's own bodycam upload log, raising questions about the accuracy of the report's factual record. On 3rd, the sequencing of the radio transmission at timestamp 2044-31 indicated that probable cause determination was intended to follow rather than precede the detention, which was inconsistent with established legal standards for investigative stops. 4th, the internal affairs investigation had not been conducted in a manner consistent with IA procedural standards. Specifically, the failure to request third-party footage, the failure to interview the complainant, and the assignment of the matter to an investigator whose prior caseload created a potential pattern of concern with respect to the subject officer. The findings did not use the word corrupt. They used the words procedural irregularity, potential conflict, inconsistent with established standards. Legal language is architecture. You build it to hold weight without naming what's inside the walls. The recommended actions were Officer Garrett Pruitt, suspended without pay for 45 days, pending a separate criminal referral to the state attorney's office regarding the potential violation of 18 U.S.C. Section 242, deprivation of rights under color of law, which the panel was forwarding with a recommendation for review. Detective Marcus Fevery, immediately transferred from the IA division to a non-investigative administrative role, pending a separate internal review of his conduct of the O'Leary complaint and prior complaint cases. On Director Sheila Brandt, no finding at this stage pending review of the unredacted email, which the panel was formally requesting through the Office of the State Attorney General, bypassing the county attorney's exemption claim. The panel further recommended, in language that was careful but unambiguous, that the department's complaint data for the prior 5 years be reviewed by an independent outside auditor. Commissioner Tolman received the findings at 8 a.m. He read them once. He called his attorney at 8:15. He issued a public statement at 10:30. The statement said the department accepted the panel's findings and was committed to implementation. It used the word accountability 4 times. It used the phrase isolated incident 0 times. Because someone on Tolman's staff had understood that those 2 words, in this particular week, would be treated as an accelerant. Pruitt was at home when the findings were delivered to his attorney. He read them in his kitchen, standing at the counter, still in the clothes he'd slept in. The 45-day suspension without pay was the number that registered first, not the criminal referral. The criminal referral was abstract. The suspension was concrete. It had a dollar figure attached to it. He put the document on the counter. He looked at his kitchen, the coffee maker, the fruit bowl, the calendar on the wall that still had last month's showing because no one had flipped it. He thought about calling his wife, who was at work, who had stopped asking him questions 2 weeks ago because his answers had become monosyllabic, and she had learned in 22 years of marriage that monosyllables meant he had gone somewhere she couldn't follow. He did not call her. He went and sat on the couch and turned on the television. Not to watch it, just to have something making sound. The criminal referral. That was the part he kept returning to, because that was the part Dillard had told him would probably not happen. Probably. He had taken probably and done what people do with comfortable probabilities. He had converted it, without examination, into definitely not. 18 years on the job, 700 and some arrests, 14 commendations, 3 use-of-force reviews, all closed with no finding, a pension he was 4 years from, and 1 parking lot, 1 man, 1 radio transmission. Not yet. Let me see what he's got. 6 words. The Florida Attorney General's office opened its pattern or practice investigation of the Harlan County Police Department on day 58 Under 42 U.S.C. Section 14,141, a federal statute that gives state attorneys general and the Department of Justice the authority to investigate law enforcement agencies for systemic constitutional violations. The announcement was one paragraph, issued by the AG's Communications Office at 2 p.m. The Florida Attorney General's Office has initiated a review of the Harlan County Police Department's policies and practices regarding investigative stops, complaint handling, and internal affairs procedures. This review is consistent with the office's mandate under applicable federal law and does not constitute a finding of wrongdoing at this stage. At this stage. The phrase appeared even in the AG's language. The system spoke in stages, the acknowledgement that things were being looked at while withholding the acknowledgement that anything would be found. It was the institutional equivalent of a door that was open but not yet entered. Nadia Cross published her second story that day. Shorter than the first, and in some ways more damaging. A data piece. 5 years of complaint records obtained through FOIA, analyzed by demographics. 73% of complaints about investigative stops without charges filed came from Black residents. Black residents made up 41% of Harlan County's population. And the disparity was not explained by arrest rate or crime geography. She had checked both. It was a raw disparity in who got stopped, held, and released without cause. She did not editorialize. She put the numbers next to each other and let readers do the arithmetic. Commissioner Tolman's phone rang for 6 straight hours. Damon was in his apartment on Crestline when Nadia's second story published. He had read the panel's findings the morning they came out, not with satisfaction exactly, but with the particular relief of a person who has been carrying something heavy for a long time and has finally been allowed to set it down, not on solid ground, on something more provisional, a surface that might hold. He was at the table with the blue notebook when his phone rang. Patricia Wade. "The timeline is clear," she said without preamble. 3 of the 5 targets are in custody. 2 are pending. The 2 pending are the names in the sealed indictment. The redacted names? Yes. He looked at the window. How long sealed? That's above my pay grade to predict. A pause. What I can tell you is that your documentation, the footage, the chain of custody, the IA record, has been added to the federal evidentiary file. It supports the broader picture in ways that were useful. I didn't build it for the federal file. I know. She said it simply, without apology. But it ended up there, and it was useful there. Another pause. Longer this time. Mr. Ellery, the work you did here was not what you were deployed to do. You were deployed to gather financial intelligence in a specific network. What you ended up doing was documenting, with precision and patience, a systematic failure in this department that went back years before you arrived. That documentation exists now. It's in the record. It can't be removed. She paused one more time. That's not nothing. He was quiet for a moment. No, he said. It's not. The call ended. He put the phone down. He looked at the blue notebook. 67 pages now, dense with dates and numbers and cross-references. He picked up a pen and wrote one more line at the bottom of the last page. Then he closed it. The Harlan County City Council convened a special public session on day 63. The session was not required by law. It was called by 3 council members who had read Nadia's data piece and understood that the choice between acting voluntarily and being compelled to act by the AG was a choice they still had for approximately 2 more weeks, and the chamber held 140 seats. 172 people were present. The overflow stood in the hallway with the door open. Commissioner Tolman made an opening statement. He talked about the department's history of service, its commitment to the community, The steps already taken, the suspension, the transfer, and the steps being planned. A review of bodycam policy. A restructuring of the IA complaint assignment process to prevent the kind of potential conflict identified in the panel's findings. And an independent audit of the past 5 years of complaint data. It was a prepared statement. It was competent. It said the right things in the right order. Then the public comment period opened. Reverend Aldous Kimball went first. He was 64 years old and had led the First Community Church of Eastbridge for 22 years and had a way of speaking that had nothing performative in it. Just the accumulated weight of a man who had sat with a great many people through a great many difficult things. He did not talk about Damon specifically. He talked about the 17 families in his congregation who had come to him over the past 3 years with variations of the same story. Stopped, held, questioned, released, never charged, never explained, never followed up with. He talked about a 16-year-old boy who had stopped walking to school alone after being detained twice in 2 weeks in the Eastbridge Commercial District. He talked about a 40-year-old woman who ran a catering business and had started taking longer routes to avoid the 5th District because the shorter route meant going past Zone D. This is not about one officer, he said. This is about what people in this community have been absorbing quietly for years, because they did not believe that saying something out loud would accomplish anything except making them a target. The chamber was very quiet. Then Nadia Cross stood up. She did not speak as a member of the public. She spoke as a reporter placing documents into the public record, which is a different and more durable thing. She opened a folder. I'm reading from a FOIA response. Document 17 of 34, dated 9 days before the incident at Riverside Mall. From Marcus Fevery, Harlan County PD Internal Affairs, to Sheila Brandt, Public Affairs. Subject line, RE Zone D / North Lot / Schedule Review. The body text is redacted. The referenced attachment has been removed from the county system. She looked up at the panel. I am submitting this document to the record and formally requesting that this council direct the county attorney to pursue full unredaction through the AG's office. And I am asking, on the record, why an internal affairs detective was communicating with the head of public affairs about a specific parking location 9 days before a federal operative was detained there by a patrol officer. The council chair looked at the county attorney, who was seated to his left. The county attorney did not have an answer that was both accurate and comfortable. He said the matter was under review. Nadia sat down. She did not look satisfied. She looked like a person who had put one more stone in a wall and was calculating how many more it would take. Marcus Fevery submitted his retirement paperwork on day 66. 22 years of service. Pension vested. The filing was administrative, submitted through the HR portal at 11:14 a.m., approved by the end of business the same day. He cleared his desk that afternoon. Not dramatically, not quickly, just systematically. The way a person packs when they have decided to go and have stopped arguing with the decision. He did not issue a statement. His union rep issued one on his behalf. Detective Fevery has served the Harlan County PD with dedication for over 2 decades and has decided to pursue retirement. He wishes the department and his colleagues well. The wish was noted. Its sincerity was not widely assessed. The unredacted Fevery Brandt email remained sealed under the investigative exemption. The AG's office had filed a formal request to override the exemption. The county attorney's office had responded with a legal brief arguing that the exemption was valid. The exchange would continue in administrative proceedings for months. This was not unusual. This was exactly how things worked when the document at the center of a dispute was damaging enough that one side would spend considerable resources keeping it sealed, and the other side would spend considerable resources opening it. The wall was there. People were still building it, and other people were still trying to get through it. That was the process. That was what it looked like from the inside. Sheila Brandt returned to her office on day 68. She did not issue a press release about her return. She came in quietly, answered emails, attended a meeting about the department's revised social media policy, and left at 5 p.m. Her position was not listed as vacant. Her name was still on the door. 3 council members had written to Commissioner Tolman asking that she be placed on administrative leave pending the resolution of the email inquiry. Tolman had responded that he was monitoring the situation. That was the language of a man who had learned which things he could delay and was delaying them. Nadia noted all of this in a third story, shorter than the others, which ran the following week under the headline, "Questions remain as HCPD officials return to work." It was factual, tight, and achieved the specific kind of damage that factual tight writing achieves when the facts are themselves damning, not through argument, but through sequence. This happened, then this, then this. Here is where things stand. It is not the writing that stings. It is the sequence. The state attorney's office in the 4th Judicial Circuit of Florida received the IA panel's criminal referral on day 70 and assigned it to a prosecutor named Brian Colston, who worked in the Civil Rights Unit and had handled 7 police conduct cases in 4 years, none of which had resulted in a criminal trial, and 4 of which had resulted in plea agreements that involved something between a slap on the wrist and a meaningful consequence, depending on your tolerance for half measures. Colston read the referral. He read the bodycam transcript, and he listened to the audio. He read the radio transmission at timestamp 2044-31 3 times, the way you read something you want to make sure you're hearing correctly. Not yet. Let me see what he's got. He called his supervisor and said, "This one has a problem." His supervisor said, "They all have a problem. What's the specific problem?" The specific problem is that the audio makes the sequence unambiguous. He detained, then went looking for cause. Under Terry, that's backwards. Under Wren, it's harder. But Wade's presence and the federal status of the subject complicates Wren significantly. I think we have a 18 U.S.C. 242 case. I think it's not a guaranteed conviction, but I think it's a prosecutable case. His supervisor was quiet for a moment. The union's going to fight it. They always fight it. Colston. A pause. It's an election year. Colston looked at his desk. He looked at the audio transcript he'd printed out. He looked at the line in the middle of the page, the one that said, "Not yet. Let me see what he's got." "I know," he said. "I'm going to file it anyway." He filed the charging recommendation 48 hours later. The determination of whether to proceed would rest with the state attorney himself, who would take 11 more days to decide, during which time Pruitt's attorney would make 3 separate calls to the state attorney's office, and Dillard would file a preemptive motion arguing that qualified immunity under Harlow versus Fitzgerald precluded prosecution. Colston responded to the qualified immunity motion in writing. Qualified immunity applies to civil litigation under 42 U.S.C. Section 1983, and not to criminal prosecution under 18 U.S.C. Section 242. The Harlow standard is not a shield against criminal charges. The motion was legally incorrect and appeared to conflate 2 separate bodies of law. The motion was denied. The state attorney announced on day 81 that criminal charges would be filed against Officer Garrett Pruitt under 18 U.S.C. Section 242, deprivation of rights under color of law. 1 count. The press release was brief, factual, and used no adjectives. Pruitt was arraigned 11 days later. He pled not guilty. He was released on his own recognizance. Pre-trial proceedings were expected to span 6 to 12 months. His attorney, at the steps of the federal courthouse, said his client had exercised reasonable judgment and looked forward to being vindicated at trial. His voice was steady. His eyes were not. And Damon watched the arraignment press conference on a laptop in his apartment on Crestline Avenue. He watched it once, straight through, no notes. Then he closed the laptop and sat for a while in the quiet. The operation was done. 3 people were in custody. 2 indictments were sealed. The financial network that had been moving money through Harlan County real estate transactions, attaching itself to property valuations, construction permits, assessment appeals, had been disrupted, not dismantled. Disrupted. Some of the root system was still there. Some of the people who had benefited from it were still in positions that made them difficult to reach through ordinary channels. This was always how it ended. Not with the full accounting, not with every name above the fold. With disruption. And with the partial picture that the system could process at a given moment, and the rest left for the next case, the next filing, the next person who was willing to be patient in a parking lot at 8:41 p.m. He picked up the blue notebook. He turned to the back cover, the inside, where he had written 4 digits in pencil when he first arrived in Harlan County 14 months ago. A case number. An authorization code. The kind of number you write down so you remember where you started and can measure. Later, how far things have moved. Things had moved. Not as far as they should have. Far enough to matter. He opened the notebook to the last page, the one with the final line he'd written the day Wade called. He read it once. Process is slow, records are permanent. Then he put the notebook in the box with the other 13. And the federal monitor was appointed on day 91. An independent oversight officer placed within the Harlan County PD for an 18-month term under a consent agreement negotiated between the department and the AG's office. The agreement covered 3 areas: bodycam policy and footage retention, IA complaint assignment and review, and documentation standards for investigative stops. The agreement was signed in a conference room at the AG's office in Tallahassee. Commissioner Tolman signed it. The AG signed it. A federal judge approved it the following week. The agreement did not require firings. It required process changes, documentation changes, audit mechanisms. It required that the department track, by demographic, the basis given for every investigative stop, and that any stop resulting in detention without charges be reviewed by a supervisor within 72 hours. Whether those processes would be followed, whether the audit mechanisms would have teeth, whether the supervisor reviews would be genuine rather than procedural. Those were questions the next 18 months would answer or not answer. The monitor's name was Carol Beaumont. She had done this work in 2 other jurisdictions, one in Georgia, one in Ohio. In Georgia, the consent agreement had produced measurable change within a year. In Ohio, the department had complied with the letter of every requirement, and the culture had shifted almost not at all. She had learned to distinguish between the two by watching what happened to the people who filed the first complaints. She made a note to herself, on her first day, to find out what happened to Damon Ellery. He had moved out of the Crestline Avenue apartment on day 85. The lease had been a short-term arrangement from the beginning, always intended to end. He packed his things in the same 3 boxes he'd brought in, plus 1 additional box for books acquired during 14 months in one place. He put the boxes in his car. He returned his key to Pete, the superintendent, who shook his hand without asking where he was going, which Damon appreciated. He drove past the Riverside Mall on his way out of Harlan County. Zone D was visible from the road. The yellow sodium lights, column P4, space 14, currently occupied by a minivan. He didn't slow down. He looked at it for as long as it was in frame through the passenger window, then looked at the road ahead, where he had a meeting in Tampa in 3 days, a debrief, then a reassignment review, then 2 weeks of what his supervisor called transition time, and what was, functionally, leave. He'd been on similar leave twice before. He knew what he would do with it: read, run, sleep, and try to reconnect with the version of himself that existed outside of the quiet precision that deployments required. It took time. It always took time. But it came back. He drove north on I-75 with the windows down and the radio off. The sun was behind him, and the road ahead was clear and long. Nadia Cross published a 4th story on day 94. This one was different in tone from the others. Less data, more reconstruction. She had spent 6 weeks piecing together the sequence from September 19th. Pruitt's decision to enter Zone D, the timeline discrepancy, the radio transmission, the bodycam upload, Fevery's log entries, the email 9 days prior. She laid it out in order. She named every decision point. She let the reader watch each actor make each choice. She did not tell the reader what to conclude. She didn't need to. The piece ran 3,000 words and was shared, by the end of the first week, more than any other story the Harlan Gazette had ever published. Nadia received a message through the paper's contact form 48 hours after publication. The sender's name was not filled in. The subject line read, "Page 17." The body of the message contained 1 sentence. The attachment referenced in that email was a schedule, not of locations, of people. She read it 3 times. She forwarded it to a secure inbox. She did not reply. She added it to the folder in the locked desk drawer at home, next to the printout of page 17. And she sat for a long time at her kitchen table in the particular stillness of a journalist who has just been handed the next story and knows it will take a year to report correctly. A schedule, not of locations, of people. Damon had been at Zone D on the evening of September 19th to meet someone. That person had seen the patrol car and left. She had never reported on who that person was, or why Damon was meeting them, or what that meeting had been meant to accomplish. She had not had enough to report. Now she had 1 sentence more. Not of locations, of people. She opened a new document. She typed the date at the top. She saved it under a file name she would not explain to anyone else. She began. Then on the 102nd day after the arrest, Garrett Pruitt received a letter from the Harlan County Police Officers Association. It was formal, brief, and concerned the matter of his legal defense. The association would continue to provide legal representation through the pre-trial phase. It would not, given the nature of the federal referral and the specific language of the charging document, commit to funding a full criminal trial defense. There were provisions in the union contract regarding federal criminal charges that were specific and limiting. He was encouraged to consult with the association's attorney about his options. He read the letter in his kitchen. He folded it along its original creases. He put it on the counter. He thought about the 32 years he had been putting money into the union. Dues, on every paycheck, automatic deduction. He thought about what he had believed that bought him. He did not call Dillard. He called his brother in Jacksonville, who was not a lawyer and not in law enforcement, and had been asking him since week 2 what he was going to do, and to whom Pruitt had been giving non-answers for weeks because he did not have a real one. "I think I need to start looking at my options," Pruitt said. His brother said, What does that mean? I don't know yet. A pause. I'll figure it out. He put the letter in a drawer. He went to the window. Outside, the neighborhood he'd lived in for 19 years went on in the ordinary way of neighborhoods. A car pulling out of a driveway, someone walking a dog, the late afternoon light going flat and golden over the rooftops. It was a life. He had built it with certain assumptions about how things worked and what he could do without consequence. Some of those assumptions had been wrong for a long time, and he had not examined them. You don't examine the assumptions that are working for you until they stop working. 3 months after the arrest, Harlan County, early December, 61 degrees and a thin overcast, the kind of weather that feels like waiting. The AG's investigation was ongoing, preliminary findings expected in the first quarter of the new year. The federal monitor had completed her first month of observation and submitted a preliminary report to the Consent Agreement Oversight Committee. The report was not public. A summary was. It noted that bodycam compliance had improved by 31% in the first 30 days under the new policy. And it noted that stop documentation had improved in completeness. It noted that culture change was a longer process than policy change and should not be expected to track the same timeline. Commissioner Tolman had survived, politically for now. 3 council members had introduced a measure to create an independent civilian oversight board with subpoena authority. The measure was in committee. Whether it would survive committee was not yet clear. Sheila Brandt was still in her office. The unredacted email was still sealed. The county attorney's brief was still in front of an administrative judge. The decision would come when it came. Fevery was at home, retired, 11 days into what was going to be a long and quiet remainder of a life. He had not spoken publicly. He had not been charged with anything. He might never be. Depending on what the unredacted email contained, depending on what the AG found, depending on which of the several processes currently in motion resolved in which direction. Pending was not the same as closed. It was, in the legal architecture of how these things moved, something more like a door still open in a building that had not yet finished burning. The 2 redacted names in the sealed FBI indictment remained redacted. No one had explained them publicly. The FBI had not commented. Patricia Wade had not commented. The press had speculated, but speculation without documents is just noise. The 11-minute gap in the Riverside Mall footage from 8:33 to 8:43 p.m. on September 19th had not been explained to anyone's satisfaction. Terrence Good maintained it was a system error. The system log corroborated this. The system log was generated by the same system that had the error. There was, as yet, no independent verification. It remained a gap. In the record, in the story, in the account of what had actually happened in Zone D before Pruitt's patrol car came through. Nadia Cross drove to the mall on a Wednesday afternoon. She parked in Zone D, space 14. She sat in her car for a few minutes, looking at column P4, looking at the camera mounted above it. The one that had recorded everything except those 11 minutes. She was not there for any particular reason. She was there because sometimes you have to go and stand in the place where something happened in order to feel the shape of it properly. To understand not just the sequence, but the weight. A man had stood here, and he had been doing his job, a job no one in this parking lot knew about. He had been patient and careful and thorough, and someone with a badge and a patrol car had made a decision about him based on information that fit in 3 words. He was there. He was alone. He was black. And from that decision, that parking lot decision by one officer on one night, had come paperwork, hearings, recordings, emails, investigations, a federal monitor, a criminal referral, a state AG inquiry, 3 news stories, a 4th one in progress, and whatever was going to happen next. Not because the system had worked, because one person inside it had documented everything and refused to let the documentation disappear. She started her car. She had a source to meet in 40 minutes. She had a 5th story to report and a 6th one forming behind it, and the sentence in the message from the anonymous sender still open in a document on her laptop. Not of locations, of people. She pulled out of space 14 and drove east, out of Zone D and onto the main road and then the highway, and the mall receded in her rearview mirror until it was just a shape against the overcast sky. In a building 3 miles north, in a 3rd-floor office whose nameplate now read Administrative Records, a generic designation that meant nothing specific and was therefore difficult to investigate. A computer terminal that had been inactive for 11 days showed a login at 11:47 p.m. No one was in the building at that hour except the overnight security guard, whose rounds did not cover the 3rd floor on Wednesdays. The login lasted 9 minutes. 1 file was accessed. 1 file was closed. The access log showed a read event, not a write event, not a delete event. A read. Someone had gone back to read something, not to change it, just to look at it one more time. The access log would not be reviewed until the Federal Monitor's audit team ran their first sweep of administrative terminal activity, 41 days later. By then, the login event would be 1 line in a spreadsheet of 11,000 lines, flagged automatically by the audit software for off-hours access, sitting in a queue waiting for a human being to look at it. It would wait. Everything in this story had waited for something. The bodycam file, sitting in the server overflow for 3 weeks. The email, waiting for someone to request it. The footage, waiting for someone to think to preserve it. The complaint data, waiting for a reporter to do the arithmetic. And the 9-minute login waited. And somewhere, not in Harlan County, not on Crestline Avenue, not in the building with the intercom on Unit 7 that was still broken, Damon Ellery was 2 weeks into transition time and had not opened a new notebook yet. He would. He always did. If this story showed you something about how accountability actually works, not overnight, not cleanly, not completely, share it. Because the people who are counting on silence are counting on you to think this doesn't matter until it happens to someone you know.